Hi, welcome to Take from Caesar here on YouTube. My name is David Merland. This can be considered, I guess, an extension of the Codebreaker curriculum. The subject of this tutorial is the motor vehicle code. Heavily referenced will be Washington state law, because that's where I'm at. When you see what I've done with Washington state law, you'll see that it's not only a valid approach, but it's likely a compilation of laws very similar to what you'll find in your state. This approach is an extension of the research into the motor vehicle code conducted by Mr. Kurt Riggin, friend of mine, now living in Colorado. In 2005, I had a break in the work I was doing on the criminal complaint that went to Congress in January of '06. Late 2005, I had completed most of the work on it, and I got curious about my traffic court briefing because it had a string of victories, and I went through the brief and through the brief and through the brief memorandum, much like the one you'll see here. And I looked at the brief with the question in mind: what is it about this brief that makes traffic court abandon traffic ticket after traffic ticket? And on my way through the memorandum, there was a very particular phrase that stood out to me every time I read through the brief. One particular phrase, head and shoulders above everything else in the memorandum, caught my attention. And we'll see it. It was a law from 1961 here in Washington State that defined the term public highway as any way, lane, street, road, boulevard, or other surface open as a matter of right to public vehicular travel. And of course, because of the volume of Supreme Court cases I've read, I spotted that phrase. It's artful. I thought to myself, you know, this is not just a run-of-the-mill phrase. It sounds like it signifies something. I went to google.com and typed in open as a matter of right to public vehicular travel and got 464,000 hits. It's in the law from coast to coast. It's in the law everywhere. In the following months, the people that tuned into my conference calls and radio shows, I told them, go to the web, go to Google, and do this search for open as a matter of right to public vehicular travel. Then put your state before the phrase and do the search again. Put the name of your city, your county, before the search term, and do the search again. And over the course of the next 4 or 5 months, the yield on Google got higher and higher and higher till I got 17.8 million hits on that phrase, open as a matter of right to public vehicular travel. Then I got 19.2 million hits. And then the number of hits crashed, where you would only get 250,000 hits, whereas just a month before you'd get in the neighborhood of 17 to 19 million. So someone had contacted Google and asked that the search term be scrubbed, massaged, whatever they do to cut down on the hits like that. The cat was out of the bag, though. Let's put it that way. I zeroed in on that phrase, and after that first search, and with such rich results, I started scouring the web for references, mostly in Washington State, but I collected references from many, many states. where the definition of public highway was said to be any way, lane, street, road, boulevard, or other surface open as a matter of right to public vehicular travel, and put all these in a compilation and doubled the size of my memorandum from 17 pages to 34 pages, and basically put a bow on the topic where I can find such references in laws from coast to coast, especially here in Washington State. Why would I argue a bunch of case law that says you have a right to travel? Very broadly, I've got specific statutes and other authorities that say outright highways are open as a matter of right to public vehicular travel. We know that a right is never a state-granted privilege, and a state-granted privilege is never a right. They simply don't fit the same category. So with this enhanced memorandum, I finished off the memorandum to what I felt was a satisfactory degree in magnitude, and placed on top of it a racketeering and extortion complaint of about 16 or 17 pages, naming as defendants, here's the accusation: the Motor Vehicle Code does not apply to the exercise of a right, which I've proven to exist, this right of public vehicular travel. It's what our state legislatures refer to when they want to specify or signify the right to travel upon the highways. And in the criminal complaint, it alleged that it was racketeering and extortion, this misapplication of the Motor Vehicle Code to public vehicular travelers, a conspiracy against my rights, mailing threatening communications. We're going to arrest you if you don't appear at the hearing. Mail fraud. You haven't paid the ticket yet, so we turned it over to collection, and they're going to be mailing you bills for the ticket. How is that not mail fraud? Conspiracy against my rights. They receive money from this extortion. Receiving proceeds of extortion, 18 U.S.C. 880. So I had a list of federal criminal statutes under which I alleged violations on the part of the governor, the director of licensing, 3 county sheriffs, 3 counties, a city police chief, a city prosecutor, a private prosecutor, meaning a private law firm that contracts with municipalities to try motor vehicle criminal violations, and a cop on the street, and a traffic court judge. One of everybody, at least one of everybody, involved in the misenforcement of the Motor Vehicle Code. And I brought these counts, count 1, count 2, count 3, and alleged these different violations under federal criminal statutes. And Kurt Riggin and I co-complained on that criminal complaint to the Homeland Security Committee in Congress and the Department of Justice on March 9th of 2006. So 3 months after I complained to Congress about the tax code, the Motor Vehicle Code complaint went to the reason it went to the Homeland Security Committee in Congress was because David Reichert, who is former King County Sheriff here from Seattle, he went to Congress. He quit the job as sheriff and ran for Congress, and on the Republican ticket made it into Congress as a representative. March 9th of 2006, he was a rookie member on the Homeland Security Committee. And so he was one of the sheriffs named as a defendant in that racketeering complaint. And of course, that's a ploy to eke a response out of the government. Here I am naming somebody on that committee as a racketeer, and even having gone so far as that, it still was insufficient to get a reply from government. Nobody denies a word of this argument, and as you'll see, it's purely statutory. Although there are some other authorities, you'll see this is really built on an analysis, historic analysis of statutes bringing forward from 1915. You look at the scope of the law, and it's never changed. the right to travel was manifest in the restrictive definition of motor vehicle from the very onset, the first motor vehicle code here in Washington State. And what we see here on page 1 of this compilation, this is a copy and paste from the traffic court memorandum that has so many traffic court victories. And you'll see it starts at paragraph 2.15. I left out the previous paragraphs. This is just for the purposes of this tutorial. But this is directly out of the motion to dismiss a traffic ticket. If you want to see this complaint, you would go to takefromcaesar.us and buy the Public Vehicular Travel Manual, America's Forgotten Right. If you wanted to perhaps use this in traffic court, you would buy the flash drive that has the course about this briefing and criminal complaint. And I should say that none of this is legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. The judges are half of the problem. America has no courts. The judges are the courts. It's a synonym. Courts and judges mean the same thing. What the courts do, it's the judges' conduct. We don't have any judges. They're half of the racketeering schemes I've proven under statute alone. So I have paragraph 2.15, and the issue is public highways of Washington State are open as a matter of right, not privilege, to public vehicular travel. In response to inquiries concerning this statutory claim, the Washington Statute Law Committee, the code reviser, will testify at the defendant's hearing upon this motion, has directed that very particular sessions laws constitute those upon which the RCW 46.04.320 definition of the term motor vehicle rests, or under which it is governed, and all are identical in their language regarding the scope of said term. The Washington State Code Reviser responded with an affirmation that indeed these are the historical foundation of the Motor Vehicle Code. The Motor Vehicle Code is Revised Code of Washington, or RCW 46. Title 46. 46.04 is called Definitions. Definition 320 is the term motor vehicle, defined, and that's present day. And we see here in this annotation at the bottom of the paragraph, Washington State Sessions Laws of 1915, and here you see the citations, several citations, and all of them say exactly what we see at the bottom of page 1. This is a statute. What doesn't exist in statute does not exist at all. The courts are powerless to add to statute. It's written by the legislature, our elected representatives, and in a form of government such as ours, the country here, we have a representative republic. We vest in our elected officials, legislative branch, the right to, or the authority to legislate, to regulate our rights. When it's unconstitutional, we can go to court and challenge the law. But if we don't have a challenge about that law, we go by its language. And here's the language of the definition of motor vehicle and public highway. This is key. This is the foundation of the Motor Vehicle Code, and as you move forward through time, and when I say this, I'm talking about your state. This is all from Washington. The motion to dismiss is made to address a Washington State ticket. But when you look at my approach, it's the approach to take to any motor vehicle code. You go back to the first one your state enacted, and you look for a restrictive set of definitions that does the same thing as these definitions do. It separates the definition of motor vehicle from simply traveling from place to place. So look very closely at these two definitions. This is key. This is the foundation of the Motor Vehicle Code, and through time, this scope and intent has never been altered. There's no place where the legislature said, you know, we intend to broaden the scope of the Motor Vehicle Code to apply to subjects other than what it originally applied to. Nowhere does it say that in Washington state law. So going back to 1915 through 1921, this was the definitions that Kurt Reagan seized upon. And it's the definition I built everything else in the memorandum on. Motor vehicle shall include all vehicles or machines propelled by any power other than muscular. This is when the horse and carriage was being phased out. Used upon the public highways for the transportation of freight, produce, or any commodity, except traction engines temporarily upon the highway, road rollers or road-making machines, and motor vehicles that run upon rails or tracks. So once again, a motor vehicle is all vehicles used upon the public highways for the transportation of freight, produce, or any commodity. And then we see public highway. What's a public highway? Now that we know what a motor vehicle is, we see public highways exist for 3 reasons. And that definition of motor vehicle was only applied to one of the reasons. You see how in this definition of public highways, the word "or" is underlined? Because there's 3 different reasons the highways exist. Public highway or public highways shall include any highway, state road, county road, public street, avenue, alley, driveway, boulevard, or other place built, supported, maintained, controlled, or used by the public or by the state, county, district, or municipal officers for the use of the public as a highway. That was the first one. Or for the transportation of persons or freight. That's number 2. And here's number 3. Or as a place of travel or communication between different localities and communities. When you drive to the grocery store, when you take your child to the soccer game, when you drive your car to a friend's house to have dinner or watch the game, which one of these 3 are you engaged in? When I do one of those activities, when I engage in just going from place to place, I'm using the highway as a highway. That's number 1. I'm not using it for the transportation of persons or freight. And I'm using it as a place of travel or communication between different localities and communities. I'm not using it for transportation of persons or freight. And that is the one of these 3 activities that the term motor vehicle is directed at. Page 2. That was a place built, supported, maintained, controlled, or used by the public or by the state, county, municipal officers, or for the transportations of persons or freight, or as a place of travel or communication between different localities and communities. The term motor vehicle is said to embrace only those contrivances using the highway under purpose number 2 above, and it is not said to embrace those using the highways for purpose number 3, for travel and communication, as was the conduct of the defendant now complained of in traffic court. This is the defendant's memorandum. Definition of transportation from Black's Law Dictionary: the movement of goods or persons from one place to another by a carrier, a dump truck, a bus, a semi-truck with a big trailer on the back hauling furniture or produce. It doesn't matter. By the way, this is out of Black's Law Dictionary, 6th edition. I would urge you to never use anything beyond Black's 6th. If you look at Black's 7th, you see they took all the case law out of it. And a law dictionary is not a primary authority. It's a secondary authority. And by taking the case law out, they proclaimed that a law dictionary is a primary authority. It doesn't have the force of law. And so by taking the case law out of it, it's toilet paper. So 6th edition or earlier. And I don't need to go back to the 4th edition, 5th edition of Black's Law, because the arguments I make simply don't require that I dig back in the law dictionary for much of what I do. Paragraph 2.17. In the 1961 major rewrite of the Motor Vehicle Code here in Washington State, in the 1961 major rewrite, the focus in defining its scope was shifted from the definition of motor vehicle and transportation to a distinction between privilege and common right, that right of public vehicular travel being repeatedly deemed a matter of right. In this 1961 definition of motor vehicle, we find no mention of transportation. What I just informed the reader of this memorandum, the traffic court judge, was that in 1961 there was a major rewrite of the Motor Vehicle Code. You know how the health care bill is all in one place, and bam, they enacted into law all at once. It was brand new legislation. In 1961, instead of piecemeal, statute by statute, they rewrote the Motor Vehicle Code in the state legislature and enacted the whole Motor Vehicle Code at once as a brand new rewrite of the Motor Vehicle Code. And so it required a brand new set of interpretations because it was all a brand new act all at once. Yes, that's a plot. They saw how much money they could make off of this early on. I'm sure somebody thought, you know, here it is, the motor vehicle is replacing the horse and carriage, and we see an opportunity to con a whole bunch of people into paying these fees, and we can grow government off of this if we just trick them out of this right of travel. So here on the bottom of page 2 we have a definition of motor vehicle from 1961. 4604.320. Motor vehicle shall mean every vehicle which is self-propelled and every vehicle which is propelled by electric power obtained from overhead trolley wires but not operated upon rails. An electric personal assistive mobility device is not considered a motor vehicle. That was added in 2002 for people with electric carts, disabled people. But you see here, look at those two side by side that are underlined. 2002, 1961. There were no amendments to this between those 2 years. And you see that this does go back all the way to 1915. In bold print, you see the years that this definition goes back to, and goes back to exactly that 1915 statute that we saw on page 1. Magic. So the legislative intent is that this be an offspring of the very earliest laws. This note is not something I made up. These are legislative notes pertaining to this definition. And so right here in just this one statute we see, yeah, this goes back all the way to the original Motor Vehicle Code. Page 3. RCW 9A, that's our criminal code. 9A.56.075, taking a motor vehicle without permission in the second degree. A person is guilty of taking a motor vehicle without permission in the second degree if he or she, without the permission of the owner or person entitled to possession, intentionally takes or drives away any automobile or motor vehicle, whether propelled by steam, electricity, or internal combustion engine, that is the property of another, or he or she voluntarily rides in or upon the automobile or motor vehicle, with knowledge of the fact that the automobile or motor vehicle was unlawfully taken. Taking a motor vehicle without permission in the second degree is a Class C felony. 2003. In 2003, in the mind of the state legislature, as evidenced by the language of this statute, automobile and motor vehicle were two different things. 3 times in one paragraph. Automobile or motor vehicle. Those are 2 different things. Paragraph 2.18. The removal of the term transportation from the language of the Revised Code of Washington clearly is the cause of this controversy. Support of this claim that private travel is not and has never been placed within the scope of the term motor vehicle is found in other provisions as well. Washington Sessions Laws of 1961. This is the law in the original brief that stood out to me. Those many times I read the brief, this one phrase, this law stood out to me, and it's part of Kurt Riggins' work. Chapter 1, Section 1X of the Highway Licenses Act of 1961 defines a public highway as every way, lane, road, street, boulevard, and every way or place in the state of Washington open as a matter of right to public vehicular travel, both inside and outside the limits of incorporated cities and towns. The proof that defendants' activity of public vehicular travel is, by law, a common right and not at all a privilege is overwhelming in the eyes of all but the morally bankrupt, criminally insane, and irretrievably corrupt. The law, state and municipal, foreign and domestic, is virtually replete with this framework which recognizes outright, and therefore duly protects, the defendant's right to engage in public vehicular travel and to not be subjected to any privilege code as Washington has in its RCW 46. One needn't trek into distant enactments of 1961 to find this expression in Washington State Sessions Laws. Page 4. This is from 2005. The governor, Christine Gregoire, signed this into law. She was former state attorney general. So, presumably she knows the law. And she signed this into law as we see right below it. We have the dates, the 93 yeas, 0 nays, and the other law, 44 yeas, and, the different houses, Senate and House in Washington State government. July 24th, 2005. Now, look at this. Top of page 4. An act relating to the definition of county engineer and amending a certain RCW, be it enacted by the legislature of the state of Washington. These 2 sections are each amended to read as follows. City street, every highway or part thereof located within the limits of incorporated cities and towns except alleys. County road, every highway or part thereof outside the limits of incorporated cities and towns, which has not been designated as a state highway. Number 11, highway, every way, lane, road, street, boulevard, and every way or place in the state of Washington open as a matter of right to public vehicular travel, both inside and outside the limits of incorporated cities and towns. 2005. I don't need more than that, but I have a wagon load. More proof that the right to public vehicular travel is distinguished as a conduct separate, totally irrelevant, having nothing to do with the privilege of operating a motor vehicle upon the highways of the state. Washington Laws of 2003. Look at number 11 there. Add highway, every way, lane, road, street, boulevard, and every way or place in the state of Washington open as a matter of right to public vehicular travel, both inside and outside the limits of incorporated cities and towns. Page 5. Paragraph 220. As late as July 2005, the collective mind of the Washington legislature unanimously viewed and deemed defendants' conduct of public vehicular travel to be a right and not a privilege, and Washington's former Attorney General, now Governor, approved of it. It's the law, still. So what is a public highway? In today's laws, RCW Revised Code of Washington. Top, an alley means a public highway. Arterial highway means every public highway. Center of the intersection. Center of the intersection means the point of intersection of the center lines of the roadway of intersecting public highways. City street means every public highway within the limits. County road means every public highway outside the limits of a city. And then we get to the definition of highway. Highway, for the purposes of this chapter only, means the entire width between the boundary lines of every way publicly maintained by the State Department of Transportation or any county or city, when any part thereof is generally open to the use of the public for purposes of vehicular travel as a matter of right. They could have just said for the purposes of vehicular travel if it wasn't a right. But they added at the end there, as a matter of right. Page 6. RCW 46-10-010. This is the Motor Vehicle Code, Title 46. Number 6 there on the top of page 6. Public roadway. Open as a matter of right to the general public for ordinary vehicular traffic. Washington Administrative Code, or WAC. And we see open as a matter of right. The next one, 035, open as a matter of right. And the next one, RCW 47, that's transportation. That pertains to trucks, buses, under our interstate compact with 5 or 6 other states. They all agree to these definitions for the purposes of commercial traffic. And this happens to be over a certain weight limit. That's why Title 47 is separate from Title 46. Title 46 are the smaller motor vehicles. Title 47 are the big motor vehicles. Number 11, I'm scrolling. This is page 7 now. Page 7. Highway, open as a matter of right. The next one, 46.30.010. .010. That's the first statute in Chapter 30 of Title 46. This is the chapter requiring motor vehicle insurance. Remember, automobile or motor vehicle. The Motor Vehicle Code never says automobile. It only directs itself to motor vehicles. It is a privilege granted by the state to operate a motor vehicle upon the highways of the state. It didn't say it's a privilege granted by the state to operate an automobile. 46.98.020. The provisions of this title shall be construed in para materia, as though, as a matter of prior legislative history, they were not originally enacted in the same statute. The provisions of this title shall also be construed in para materia with the provisions of Title 47. Title 47 is about big motor vehicles, trucks that need that weight sticker on the side. In para materia means as relating to or pertaining to the same subject as the other law, if it's read in para materia with that other law. And then it goes on. See those quotation marks in the middle of the page there? The state laws governing vehicles. This is beginning to quote a Washington State Attorney General's opinion that is, the site is on the following page, okay? The state laws governing vehicles and public highways are set forth primarily in Title 46 and 47. The provisions of these two titles, together with other laws pertaining to highways and roads, are to be construed in para materia, meaning they apply to the same thing, and neither mention automobiles. Indented. The provisions of this title relating to vehicles shall be applicable and uniform throughout this state and in all incorporated cities and towns and all political subdivisions thereof, and no local authority shall enact or enforce any law, ordinance, rule, or regulation in conflict with the provisions of this title, except and unless expressly authorized by law to do so, and any laws, ordinance, rules, or regulations in conflict with the provisions of this title are hereby declared to be invalid and of no effect. Local authorities may, however, adopt additional vehicle and traffic regulations which are not in conflict with the provisions of this title. Look at the footnote at the bottom of page 7, the definition of privilege from Black's Law Dictionary. A particular and peculiar benefit or advantage enjoyed by a person, company, or class beyond the common advantages of other citizens. An exceptional or extraordinary power or exemption, a peculiar right, advantage, exemption, power, franchise, or immunity held by a person or class not generally possessed by others. Definition of license. A personal privilege to do some particular act or a series of acts on land without possessing any estate or interest in them, and is ordinarily revocable at the will of the licensor and is not assignable. The permission by competent authority to do an act which, without such permission, would be illegal, a trespass, a tort, or otherwise not allowable. Page 8. We're still quoting this Washington Attorney General's opinion. Turning to the specific statutes, RCW 46.61, that's Rules of the Road, sets forth the rules of the road for the operation of motor vehicles. Didn't say automobiles. While Chapter 47.36 sets forth the responsibilities of local authorities regarding traffic control devices. A highway is defined as the entire width between the boundary lines, blah, 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 open as a matter of right to public vehicular travel. And we're in a privilege code. That was Washington State Attorney General's opinion, 1996, number 17. And here we have municipal provisions from Washington State counties. And at the bottom of the page you see the footnote 7, which has the definition of impera materia. If you wanted to, you could probably pause this presentation and read that, or go look it up yourself. I'm not going to pause to read it. Franklin County Code, Jefferson County, Washington. Kittitas County Code, Washington. Continued on the next page. Page 9, Highway, open as a matter of right. Pierce County, open as a matter of right. Snohomish County, open as a matter of right. Yakima County. Page 10, Washington City Code provisions. Asotin, Washington. Bremerton, Washington. Cathlamet, Washington. Edgewood. Everett, open as a matter of right. Page 11, Kent, Washington. Lakewood, Langley, Linwood, Marysville, open as a matter of right. Page 12, Monroe, Pasco. Notice these are in alphabetical order. This is for the court. I want all of my T's crossed and I's dotted on everything that goes into the court. When I do that, the prosecutor and the judge know long before I even show up to argue the motion that I know how to write, and they've got their hands full. They see everything in near perfect order in the pleadings I submit, and I want them to know right off the mark that we're in court for business. The court is not my friend, and the court is not yours, Your Honor. The court is a chamber of rotating knives into which I drag my opponents. Let's begin. Pasco, Washington. Port Townsend. Seattle. Seattle. Look at this definition of way open to the public, bottom of page 12. Very interesting. Way open to the public. And what I'm shooting for here is, this is a more broad term. If I operate a parking lot in downtown, you can park your car there, $10 for all day, and people are allowed to walk across that parking lot and cut the corner. Let's say it's at 5th and Pike, and they're walking down 5th. They don't have to walk all the way to the street corner to take a right. They could cut across the parking lot. Way open to the public means any road, alley, lane, parking area, path, or any place, private or otherwise, adapted to and fitted for travel that is in common use by the public with the consent, expressed or implied, of the owner. Page 13, SeaTac. Bet you'll never guess where that is. You're right. It's a little municipality between Seattle and Tacoma, and someone frightfully creative. Let's name it SeaTac. We're on page 13. Spokane, Sumner, Tukwila, West Richland, open as a matter of right to public vehicular travel. Look at this orgy of evidence of the existence of a right to travel. If I can find all this in Washington, wouldn't you think that in your state you can find provisions in kind? And that's your assignment if you want to argue this way in traffic court or anywhere else they say you owe money under the Motor Vehicle Code. Provisions like this are everywhere, and you see this in the definition of public street, public highway, in statutes concerning loitering or civil engineering, maybe even in your Motor Vehicle Code. You want to go back to the earliest Motor Vehicle Code and look at the definitions and see what the intent was when they first wrote the law, and then do your workup from the beginning all the way till present day and find all references to open as a matter of right to public vehicular travel or public vehicular traffic. I found that in Florida law. Page 14, Yelm. And now we move on to foreign law, law that is not in Washington state, on the state or municipal level. Foreign law, foreign to Washington. Here's Arizona, open as a matter of right. Colorado, Colorado. Page 15, again, alphabetical order. Colorado, Delaware, Florida, Iowa, Idaho. Page 16, Idaho, Minnesota, New Mexico, New York, North Carolina, open as a matter of right. See that North Carolina statute? For the purposes of vehicular traffic. So it might not always be exactly the same term, but this gives you a general idea of what you're looking for. Page 17. Oregon, Pennsylvania, Pennsylvania, Texas, Utah, times 3. The middle one, look at that. Driving privilege means the privilege granted under this chapter to drive a motor vehicle. Didn't say to drive an automobile. Page 18. Another Utah statute, open as a matter of right. Foreign law, municipal. These are municipal ordinances outside of Washington state. Santa Barbara County, California. City of Glendale, California. Page 19. Park County, Colorado. Open as a matter of right. Brighton, Colorado. Blanca, Colorado. Dillon, Colorado. Page 20. Pueblo, Colorado. Gee, do you see any of these in Colorado? If I dug deeper, I'd probably find a wealth of this reference in Colorado as I found in Washington. These are all off the web on the search for open as a matter of right to public vehicular travel. Silver Bow, Colorado, and I'm on page 20. Boise, Idaho. Haley, Idaho. Page 21. Haley, Idaho. Ramsey, Minnesota. Clark County, Nevada. Linden, Utah. Page 22. Well, I'm glad that's over. Paragraph 2.22. The public highway upon which the defendant was traveling when issued the subject citation, remember we're in traffic court, was open as a matter of right and was therefore not the privilege to which the plaintiff has alluded. Indeed, Historic Notes to Revised Code of Washington definition of motor vehicle shows its origin to be consistent with both 1961 and 2005 Sessions laws, that upon the birth of said RCW public highways were open as, to public vehicular travel as a matter of right and not as a matter of privilege. Since 1961, we note there has been only one other legislative session upon said definition in point 320. And here we see 2002 right beside 1961. So there's no rewrite of the definition of motor vehicle, and it's always applied. And as you look at that annotation, going back to 1915. 2.23, a snapshot of the law as it stood in 1961 and how it now stands in 2005's Sessions laws, placed beside all legislative amendments, none, virtually throughout the state, show that all public highways are still open to the public, open to public vehicular travel as a matter of right. That RCW 46 applies only to transportation, which makes perfect sense when one considers that everything a transportation company, any company, does is a privilege. Companies have no rights. A public highway is clearly a public easement, open to defendant by permission of the owner, and not open only by the grant of license from the state. 2.24. As recently as 2003, we see the legislature clearly views automobiles and motor vehicles to be entirely different subjects. When a thing is mentioned in one statute and not mentioned in another, legislative intent must be, page 23, must be deemed to be that the thing shall be excluded from the latter provision. Footnote number 8. Look at footnote number 8, U.S. versus Patzer. A very interesting case. Patzer drove from Washington to Idaho, and he was stoned on pot. The state trooper in Idaho, I think it was an Idaho trooper, it might have been Washington cops that called the Idaho cops and said, you know, this guy just drove into your state from Washington, and he's got a, or vice versa. We see it was argued in Seattle, Washington, U.S. District Court. Whatever. Now, he was stoned on pot, and that was the reason that he was pulled over. And I think it was by an Idaho State Patrolman for suspicion of having violated their drunk driving statute, or driving under the influence statute, DUI. And it was argued in that case, look over here at these definitions, Your Honor. The definition of narcotics. And in this definition it says this, that, the other thing, and marijuana. And in this definition it says this, that, and the other thing, and marijuana. But over here in the definition of narcotics for the purposes of the drunk driving statute, or driving under the influence statute, it says you shall not consume this, that, and the other thing, and operate a motor vehicle, and it doesn't mention marijuana. That's indicative of legislative intent that marijuana be a substance the abuse of which shall not trigger the drunk driving statute. And the district court said, no, he's convicted. Had illegal guns and drugs. And on appeal, the Ninth Circuit said, oh no, the search was unlawful because the basis for the search of his automobile was for an offense under the drunk driving under the influence statute, and marijuana is not part of that statute. And so the arrest, the traffic stop was made without probable cause. And so you have to suppress the evidence. That's what U.S. versus Patzer was. And that's from 2001. And it came out in the newspaper, oh, it's legal to smoke pot and drive in Idaho. That's the case that said so. Back to the top of page 23, second sentence. It is a matter of right by which the defendant uses any public easement or public highway for vehicular travel according to the legislature, and it is a matter of right vested in the public generally in the minds of the authors of Black's Law Dictionary. Easement, a right of use over the property of another. Private or public easements. A private easement is one in which the enjoyment is restricted to one or a few individuals, while a public easement is one the right to enjoyment of which is vested in the public generally or in an entire community, such as an easement of passage on the public streets and highways, or of navigation on a stream. Did you know that, let's picture a downtown street, you have a yellow line up the middle, and adjacent businesses on property that are privately owned. Their ownership of property goes all the way out to the middle of the road. The property owner has devoted that land to use by the public as a public easement. How can the state grant you the privilege of driving on land that belongs to a private party? It's not a privilege at all. It's a right. Paragraph 2.25, under the authorities cited above, there is no basis for subjecting the common right of public vehicular travel to the provisions of a privilege code such as RCW 46. As to the meaning of the term public highway, statutory definitions are clear. And these are cases from the state level. You see footnote number 10, State versus Taylor, Washington Appellate, 1981. Definitions are integral to statutory scheme and of the highest value in determining legislative intent. To ignore a definition section is to refuse to give legal effect to part of a statutory law of state. When legislative body provides definition for statutory terms, it is that definition to which a person must conform his conduct. Footnote 11 is on the bottom of the next page, page 24. We see that footnote number 11, City of Seattle versus Co. 1980. And you could read these later. These simply say, these are state courts saying that a definition governs. You have to obey the definition of a term. It's there for a reason, and we can't change it. We're just the courts. You have to look at the definition, and that alone controls. Paragraph 2.26. Of the three reasons highways are said to exist, the term motor vehicle clearly applies to only one of said reasons, that being transportation of goods, commodities, and persons. Page 25. An examination of the statutory context, the text of the relevant provisions, and the legislative history convinces us that the construction that is most harmonious with its scheme and with the general purpose that Congress manifested, meaning this is a federal case. Moreover, because the application of the provision to these loans is ambiguous, we follow the venerable rule that in the interpretation of statutes levying taxes, courts must not enlarge their operation so as to embrace matters not specifically pointed out. Footnote 15. This is Security Bank of Minnesota versus Commissioner, where the first thing the court says in its opinion, I think, says the commissioner and the bank, the parties have vastly differing interpretations of the same statute. We, as judges, must proceed in such and such a fashion. And the judge outlines what the role of the court is, how they have to approach such a dilemma, where both parties are looking at the same statute and they have vastly differing interpretations of the same thing. That's why I quote this case right here, because traffic court and I part ways. The prosecution and I part ways. We're looking at the same statutes, but we have an entirely different interpretation of the statutes. I say it's a right, and I say I have a lot of proof of it, and they say, oh no, it's a privilege, and they got to come in with their best argument. Why? Because I know how to write. The brief is impeccable. And then general language, 2.28, the right of the defendant to arrange his own affairs in any lawful manner or way cannot be denied. Then there's more argument about this. It's just argument about the issue. Page 26, Washington State Attorney General's Report, 1951 to 1953, number 62. Not in its entirety. Indented, public highway. Any way, lane, street, road, boulevard, blah, 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 open as a matter of right. And so in discussion about the law, the Washington State Attorney General feels free and compelled, really, to say open as a matter of right to public vehicular travel. Page 27. Attorney General's Report, 1959 to 1960, number 88. Speaking specifically of motor vehicles, operator's license, law enforcement, authority to stop a motorist to see their operator's license. They're an operator of a motor vehicle. And here the Attorney General cites CJS, that's Corpus Juris Secundum. It's a directory of law. It's an encyclopedia of American jurisprudence. Personal liberty, or the right of the enjoyment of life and liberty, is one of the fundamental or natural rights which has been protected by its inclusion in a guarantee in the various constitutions, which is not derived from or dependent upon the federal Constitution, and which may not be substituted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right of private property or as occupying a preferred position as contrasted with property rights, and is regarded as inalienable. That's a quote from Corpus Juris Secundum. The Attorney General then says, this concept is further amplified in 11 American Jurisprudence, which is another directory of law. It's an encyclopedia of American jurisprudence. Constitutional Law, Section 329, page 1135, wherein it is said, and this is good enough for the State Attorney General, personal liberty largely consists of the right of locomotion, to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of a citizen to travel upon the public highways and to transport his property thereon, by horse-drawn carriage, wagon, or automobile, is not a mere privilege, which may be permitted or prohibited at will, but a common right, which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may, therefore, under normal conditions, travel at his inclination along a public highway or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected not only in his person, but in his safe conduct. End quote. The Attorney General then says, see also Tech Lines Incorporated versus Danforth, Mississippi, 1943. Page 28. We're still in the Washington State Attorney General's opinion. In Barber versus Walker, the distinction between the right of a citizen to use the public highways for private rather than commercial purposes is recognized. Bold type. The right of a citizen to travel upon the highway and transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for personal gain. In the running of a stagecoach or omnibus, the former is the usual and ordinary right of a citizen, a common right, a right common to all, while the latter is special, unusual, and extraordinary. As to the former, the extent of legislative power is that of regulation. But as to the latter, its power is broader. The right may be wholly denied, or it may be permitted to some and denied to others, because of its extraordinary nature. This distinction, elementary and fundamental in character, is recognized by all the authorities. The Washington State Attorney General, 1959. It goes on to say, beginning of that paragraph, not indented. Under its power to regulate private use of our highways, our legislature has required that motor vehicle operators be licensed. After referring to automobiles, that motor vehicles operators be licensed. Undoubtedly, the primary purpose of this requirement is to ensure, insofar as possible, that all motor vehicle operators will be competent and qualified, thereby reducing the potential hazard or risk of harm to which other users of the highway might otherwise be subject. If everything is a motor vehicle, how could there be other users of the highway? There are motor vehicle operators and there are other users of the highway. Bottom of the page, bold type. However, a right as precious as the freedom of an individual who has not violated any law to travel wherever he pleases without interruption should not be denied by implication where an equally consistent construction not impairing such a right is possible. Page 29, and we see that there's the end of that excerpt from Washington Attorney General's Opinion 1959-60, number 88. Here's another one, 1963, 1964, number 25. Definition of public highway: any way, lane, street, road, boulevard, open as a matter of right. In bold type, middle of the page, beginning of the paragraph says, if the legislature had intended that a public highway exists only on publicly owned land, it would have so stated. Whether certain designated property is open as a matter of right to public vehicular travel in order to determine the extent of the geographical application of those sections of the code wherein the term public highway is employed. Page 30. RCW 46.04.430. This is a definition. It's in 46.04. That's definitions. We conclude that any section of the motor vehicle laws wherein the term public highway is employed should have application wherever people are accustomed to congregate in automobiles in numbers sufficient to constitute a use by the public. And there are its footnotes. Street or highway means any part of the lanes open as a matter of right to public vehicular travel. Public highway, open as a matter of right. End Washington State Attorney General's Report, 1963 to 1964, number 25, page 31. That's the end of the excerpts from the Washington State Attorney General's opinions. And here we have two cases. The first one is Washington State Supreme Court. The second one is the U.S. Supreme Court. Indented. It will be observed that a highway within the contemplation of the Act is every way or place of whatever nature open as a matter of right to the use of the public for the purposes of vehicular travel. There can be no question but that this definition is broad enough to include streets in incorporated cities, because they are open as a matter of right to the use of the public for the purposes of vehicular travel. Neely v. Bach, 1935, Washington State Supreme Court. U.S. Supreme Court, Buck v. Kuykendall, 1925. The right to travel by interstate auto vehicle upon the public highways may be a privilege or immunity of citizens of the United States. A citizen may have, under the 14th Amendment, the right to travel and transport his property upon them by auto vehicle, but he has no right to make the highways his place of business by using them as a common carrier for hire. Such use is a privilege, which may be granted or withheld by the state in its discretion without violating either the Due Process Clause or the Equal Protection Clause. Well, do you need more proof than this? We're near the end of the memorandum. And now it's just argument, paragraph 2.31. At any time, of course, you can pause this presentation and read the paragraph. I'm not going to just sit here and read verbatim arguments that you could read by pausing the page. That was page 31. Moving on to page 32, a reminder that it is a privilege granted by the state to operate a motor vehicle upon the highways of the state. And this is right out of the Mandatory Motor Vehicle Insurance chapter. Questions presented for review. If I'm wrong, you can answer me these questions. And in footnote, there's a repeat of Black's Law Dictionary definition of privilege and license, just in case they forgot. Page 33, our questions for review. And you can pause this presentation and read those questions if you feel you need to. Those are the questions I thought will keep the burden on the government. We just did a whole expose on Washington state law, 3 branches of government, and municipal ordinances. And I have all of them saying open as a matter of right to public vehicular travel. Look at paragraph 3.2. This is a very simple issue of due process. Show me. The state is unable to produce anything but revised Code of Washington statutes in response to this claim. Meaning, where are the sessions laws? You produce these RCWs that are vague. When I've gone all the way back to 1915, and it says, see State versus Donald Grahn, Thurston County District Court. There's a particular case where this brief was submitted, and in the reply brief from the Thurston County prosecutor, Edward Holm, it's void of reference to statute law. And statute law, or sessions law, trumps the revised code. The revised code is a compilation from the code reviser. It's not from the state legislature. Page 34. Conclusion. And here's a summary of the claim. Affirmative statements that the court lacks in personam jurisdiction because they can't rebut these conclusions. 1, 2, 3. Page 35. More conclusions. You can pause this presentation and read those conclusions. I'm not going to go through them one by one here. This is in plain writing. And again, if you want to look at the criminal complaint that has this briefing, along with the 16 or 17 page criminal complaint for racketeering and extortion, the motion to vacate the traffic, or motion to dismiss the traffic ticket, and the affidavit of joinder that the person that went to traffic court would have filed, you can get the manual called Public Vehicular Travel, America's Forgotten Right, on takefromcaesar.us. If you want to employ the brief in a motion to dismiss and join your particular cop, prosecutor, traffic court judge, director of licensing, if you want to join them to my criminal complaint as similarly situated criminals, get the flash drive on takefromcaesar.us Public Vehicular Travel page. It has the course, which has an abundance of audio instruction included in the course on how, not for you, I don't give legal advice, but this is how I would set about using the affidavit of joinder to join them to the complaint that was filed in 2006, and to include the complaint and my affidavit of joinder as exhibits behind a motion to dismiss. And I would demand that the court have the officer that issued the ticket present at my hearing so that I can get him or her on the stand and grill them over where exactly did the right of public vehicular travel go. Tell me all about your experience and knowledge and all the teaching you underwent in the academy to become a cop. How much did they speak about public vehicular travel when they trained you to do this job? When you study the law, what's your opinion about public vehicular travel? And in most instances, they tell the officer to not appear at the hearing so they can dismiss the ticket rather than get into it. We know the officers are paid to be ignorant, and it puts the officer right in the spot between the requirement that he know the law and the fact that he doesn't know the law. And they don't want the bad press, the embarrassment that would come from an officer going, but I'm. And that's exactly what would happen, because none of them know this. Page 36. we have the conclusion of the brief. In the middle of the page, indented, to punish a person because he has done what the law plainly allows him to do is a due process violation of the most basic sort. If you went to scholar.google.com, it'll allow you to search only case law. Scholar.google.com, and click on case law and type in most basic sort, and you'll come up with a whole bunch of cases that say exactly this. And here we have Joe Lunchbucket signing his motion to dismiss, page 36. This has been the presentation on public vehicular travel. Go to takefromcaesar.us, get the flash drive, take the course, be prepared in advance of getting a traffic ticket. And for anybody setting up a Citizens Review Panel or Citizens Oversight Commission, this, of course, would be one of the extraordinary writs that the panel puts in place for all time. From the onset of your organization of a panel, I would have extraordinary writs that say any reference of this state's motor vehicle code by an officer when he's dealing with a public vehicular travel can be construed as evidence of a conspiracy against the rights of that citizen in violation of 18 U.S.C. 242, a felony, and that officer is therefore subject to citizen's arrest. And put this in place so that anybody that comes to the panel after that with a traffic ticket can get a writ from the panel saying, yep, that's a felony, we already have our brief in place, the state can't deny a word of it. So I personally, if the panel were concerned me, or if I were on the Oversight Commission, I would want an extraordinary writ about this pattern of racketeering and extortion from the very earliest of the panel's function. I would put this in place, put it on the web on our YouTube channel so everybody could see, yes, this is racketeering and extortion. Our panel believes that it is. Here's our sworn statement saying that it is, and any public officer that seeks to enforce the motor vehicle code against public vehicular travelers are, in our opinion, rightfully deemed to be felons and are subject to citizen's arrest for as long as the statute of limitation runs on their attempt to extort money or to deprive somebody else of rights by misenforcing the motor vehicle code against public vehicular travelers. So another session down. Thank you for visiting Take from Caesar on YouTube. Keep your eye out for more seminars. We're going to build upon this. You already see how very particular provisions of the tax code operate a certain way that is vastly different and contrary to what the IRS tells us we're required to do, which equals felonious misconduct. So when you ring the felony bell, you want to watch the citizen's arrest presentation here on the YouTube channel, Take from Caesar, and case after case, you can arrest a felon with any necessary force. So all of this is directed toward identifying when a felony has been committed, because that gives you all dominion over the person that committed the felony for the purposes of arresting them and taking them to the authorities and seizing evidence. In my opinion, this is what I get from the case law in the citizen's arrest presentation. What you get is your business, your prerogative, your problem. I'll put it in front of you, and as you see, everything I do is based on statute, fully supported by case law. This is law, as opposed to how the Patriot movement, the anti-tax movement, that which does not move, has historically argued. This is a focused, concentrated approach based on responsible legislative scope and intent and the analysis of statutory language. You see, I have my feet on the ground regarding all of this. And that I have questions for review they have to answer to prove I'm wrong. I have a list of conclusions that says, this is what I'm talking about. Any questions? Do you have any questions, servant? This is what I'm trying to tell you. Here are the questions you have to answer to prove me wrong. Do you have any problems? Do you have a briefing to the contrary? If not, don't. You put that pen back in your pants. And you don't do this. Because if you do this to me, there's no guarantees you won't be arrested. You know it's felonious. I know it's felonious. Everybody that visits our website and our YouTube channel knows it's felonious. We're going to have a hearing about you at the panel. The video is going to go up on the web with a copy of every piece of paper we can get that relates to you out of your employment file. We're going to get that under our State Disclosure Act. Why bother just for one traffic ticket? And understand, if you take us all the way to traffic court on this, it's not going to be about the ticket. Our conversation with the judge is going to be about, do you have any proof, Your Honor, that everyone you see every day can't arrest you for being a felon? Because that's the end game in all this. If you can't contradict my briefing, you're a felon. I've already joined you, Your Honor, through my affidavit to that complaint filed in 2006. It's attached as an exhibit to my motion to dismiss. You're a felon. Do you have any proof to the contrary? If not, what were you thinking? Your officer could have passed me up and not issued the ticket. He knew all of this. But he wanted me in your court grilling you over whether or not 317 million gun owners can arrest you. In Washington state, I can't speak about other states, but the statute of limitations on a felony committed by a public servant is 10 years. I can arrest you for 10 years just for what you did to me. You're going to do the same thing to somebody tomorrow. That means for 10 years from tomorrow I can arrest you because of a felony you committed against the next guy. Where does it end? You've been a racketeer for decades. If you quit today, you could still be arrested for 10 more years. What were you thinking? Now, you either put a contradictory memorandum on the record that proves me wrong, or I can't guarantee somebody out there isn't going to arrest you. Any questions? Servant breath? That's the checkmate that arises from this shifting of a burden. I've briefed the law. Specifically, since 1915, show me where I'm wrong. Prove me wrong. Where's your memorandum? If you don't have one and you maintain this ticket, you had your chance to back off. Now you're subject to citizen's arrest and it's going on the web. We'll have your picture. We'll have everything we can discover against you under the State Disclosure Act. And so if you got baggage out there, divorce court, tax court, IRS tax liens, maybe a misdemeanor record somewhere, we're going to have it. So you wanted it this way, you got it this way. Or you could dismiss the ticket. But I'm not here to play table tennis with you. The law's not pretty. Relax if you're innocent. But I mean business. This is about my rights. And this is finally a court again. And so, just don't. You either contradict me using the law and explain away this memorandum, or you've been warned. My name is David Merlin. None of this is legal advice. Thanks again for visiting Take from Caesar here on YouTube. Keep watching the channel for new videos. It's been my pleasure. Thanks for your support. At this point in time, I think I'm up to about 18 subscribers. I sure appreciate that. And I promise that I'll always try to deliver for you. Thanks again.
Hey, Sheriff, we have a question about why your office, your intelligence division, is investigating private citizens for criminal investigation that happen to be activists that are overseeing your department. Why would you have your intelligence division investigate private citizens? We have done...
For life hating so much.
Sir, we don't hate anyone. We love freedom and we love American people. And government is out of control. That's why you're seeing such a revolt nationwide. Why can't you just answer, why is Susan Edwards, your intelligence division, investigating private citizens? This should not happen.
Are you here to apply for a job?
Possibly I might be applying for a job, but that's irrelevant to my question. Why would you ask that question?
Well, enjoy the fair.
Okay.
Excuse me.
Excuse you?
Excuse me, sir.
So those of you that haven't
Wow.
been on a bike before,
Sheriff's getting a little too pushy. You work for us, Sheriff. Just keep that in mind. At one time we respected you, but not with that type of attitude.
Hey Charlotte County, this is Charlotte County COPWATCH, and I found that I had to make a change this ending on my videos, letting you know about the channel and fair use laws, you know, how we can report on other people's reporting and how it's good, how it's bad, etc. But you guys can look it up yourself. It is legal. It's in there. But like I've told you before, that I've been cut off from making money on YouTube for 4 years. It's really weird, bizarre, but they cut the money off, but they said you can keep the channel, and now YouTube makes all the money. And if you get bored, plug it into Social Blade website, and you'll see that they are making a huge amount off the site. Right now it's at 63 million views, 53,000 subscribers, almost 3 million views a month. You know, trying to wake people up, and I make nothing. In fact, I got a customer that's ex-congressman. He said if I could ever find a lawyer, sue YouTube on it. But because this is nuts, 4 hours a day, and to save America. You know, but at the same time, it's worth it. Look at what our founding fathers did. They died for this country. So But getting back to the money part, this is why I'm redoing the video. Is my dream of everyone giving $1, and it's going to be $53,000 a year, or if they did Patreon, which you know, can be monthly. That is not working. That'd be great if it did. Nothing is perfect. And I appreciate the people that do donate, you know, what they can on PayPal. And there again, I'm letting you guys know that is not much. Is, you know, monthly is, oh my god. So anyways, yes, you cannot live on it. It's very, very, very low amount. But the dollar things, I do appreciate that. But when I first said everybody give $1, that's not working. I'm just letting you guys know it's, yeah, that dream. Everybody gives $1. 53,000 subscribers, it's not working. So yes, if you can give more than that, you know, I appreciate it. Like I said, you know, I'm in a unique situation where, you know what, we're already debt free, and I'm not rich, but with the little business that we have, I am able to do what I am able to do 45 hours a day, you know, letting you guys know what's going on. In 4 years, I've did the whole thing myself. 12,000 videos on there. I literally get emails where people are like, holy crap, I never knew it was this bad. And it is this bad, and it's getting worse every day because we have the internet, we have cell phones, we have cameras everywhere now, and it's just disgusting what's going on. And then, as you guys know too, now we got Trump, we got Jeff Sessions doing a war on drugs, and now he wants to go after the forfeiture laws again. It's just unfreaking real. So if you can give more than that dream of everybody giving $1, yeah, that old video, that's not working. They're not. They're just not. So anyways, if you can give more than that dream is not working. Hardly anybody is giving. There you go. So that's why I'm remaking the video. If you can give more than that would be great. And there again, like I said, the Patreon's there. There is some people on there that are starting to give, but there again, it's very, very low. And like I said, I don't want to get rich off of that. I'm going to keep doing what I'm doing because, you know, it's still so stinking corrupt. It's not even funny. My court case that I'm going to be paying out of my pocket myself with Charlotte County's coming up. They illegally looked me up and then posted all my information on LEOAFFAIRS website. They basically doxed me, however you want to say that. I forget what the word is, and they outed me, man. And that information on that site went out to 500 sheriffs, deputies, people that work at the jail, etc., etc., etc. So, yeah, it is very, very scary, but we're going to do a federal case, 1983 case, violating freedom of speech. We have 17 cameras in the house now. We got 2 cameras in the car. I always carry a camera plus a cell phone. A lot of people are highly recommending I get a vest now. If I could, if the wife would let me, I would run for sheriff. We are trying to push the thing nationwide right now, where just to mix it up and to get the topics out there is register to run for sheriff, NPA, no party affiliation, as a write-in, and that is completely free, and you can participate in the elections. And there's a lot of stuff. We got a guy, James McLinnis in Pinellas County, Tampa, who almost won. He experienced the corruption himself. The story is unbelievable. Look him up. It's mind-blowing what they did. It pissed him off. He is very, very smart. He has way more money than I did. He ran for sheriff at the last 3 months last year in 2016 and almost won. He got all of the black vote. And the reason why he did that is because he ran in, I will not bust, we're in Florida, I will not bust anybody for weed anymore unless it's an ungodly huge amount, like pounds. And then he also ran in, no more victimless crimes, no more of this freaking road pirate bull crap. And then he was going to cut the budget by 30%. And when you think about that, you can. If you stop the road pirates, you can get rid of a bunch of people. Gone. So, the wife has been saying, yes, I can, yes, I can't. So I don't know. We're trying to find somebody that can do it because I am busy doing this anyways. But, so I'm making a video, like I said, that $1 a month from everybody, you know, for 53,000 subscribers, that is not working. I'm just letting you guys know. absolutely give way more than $1 a month. If you can, I appreciate anything. By the way, remember too, when you give that, PayPal takes like freaking 15 to 20%, so it's even worse than that. But and there again, like I'm letting you guys know, it's way what I get is very, very low. Appreciate it, but it is very, very low. Can't live on it. I'm just, I'm working, and that's what I'm working on. And that court case is going to cost a buttload of money. That's federal court. Just the filing fees and the depositions that we're going to be doing with this corrupt cop. So there's another reason to give. We are going to be doing a deposition with this very corrupt. He was in a drug squad. He is a bad guy. He's on steroids. We heard steroids are rampant here. That's why their attitude is so bad. And we are going to get him on video, and it will be on YouTube. So that case alone is $5,000 just to bring it to court, and that's my money out of my pocket. So there's another reason to give, and give way more than $1 if you can. So keep that in mind. This is the new video, and I see, God, I talk a lot. It's already 7 minutes, but had to make it just to let you know that $1 a month from everybody is not working. They're not doing it. So if you can give more than that, please. So thanks. Keep it up. Share, like, subscribe, tell your friends, send me your videos on corruption, and I'll post it.